The very mention of our next guest must strike fear in the heart of you-know-who right now.
That the president, as well as some of his children, perhaps inflated his assets so that they can get financial terms for loans and for insurance coverage. In addition to that, they deflated those same assets for the purposes of evading and or avoiding tax liability. It is a civil investigation in nature. However, there is a criminal investigation that's currently being conducted. President Trump cannot avoid justice in the great state of New York.
One long, angry line later.
Joining me now is U.S. Federal Housing FHFA Director Bill Pulte. Well, look, I want to switch gears and ask you about your recommendation. You recommended that the DOJ investigate New York Attorney General Letitia James over alleged mortgage fraud.
Well, I know that we are mortgage experts, and we only refer things that we think are mortgage fraud, and we stand 100% behind the letter. I'll let the letter speak for itself.
A little longer than a few minutes later.
It has to do with the fact that on a power of attorney, I mistakenly indicated that I was a state of Virginia, but prior to that, I had indicated to the mortgage broker that, in fact, in bold cap letters, that I am not a resident of Virginia and never will be.
A few moments later.
I am going to lay out the case for federal prosecutors so they have no excuse to screw up this investigation, the indictment of her and the prosecution of her. There's a 15-day story that has to be told. On August 2nd, she writes an email telling the broker, I do not intend to occupy this Sterling Street, Virginia property as a primary resident. Then the broker reiterated the following day on August 3rd, well, the mortgage application says that you're not a primary resident. All fair and good, but here's the problem. There was no way that she could obtain that loan under Fannie Mae with such preferable terms like interest rates and down payment unless she was a primary resident with her co-purchaser and co-borrower, because she purchased the property in a tenancy, joint tenancy with rights of survivorship.
Right.
Therefore, both parties had to occupy the property.
Right.
So therefore, she had to sign an affidavit saying that she intended to move to Virginia so that she could satisfy the terms of the mortgage. And ultimately, the mortgage was underwritten based upon her statement that she would be occupying the property along with Shamice Thompson, her co-buyer and co-borrower. She said that she intended to make it her primary residence. And according to the terms of the mortgage, I think it's paragraph 6, she was supposed to make it a primary residence within 60 days, which would have run right into the Donald Trump trial.
All right.
You know that she wasn't intending to move out of New York because of 2 points. Number one, she owned the property. She couldn't be a co-signer because she owned the property.
Right.
With Shamice as joint tenants. Now, that automatically put it into the investment property category. Okay, if she did not intend to occupy the property. In order not to be an investment property, she had to be a borrower-occupier with Shamice. Now, also, let's not forget that the property was purchased for $240,000. The mortgage on it was $219,780. That's about 91.6% leverage. Qualify for the special treatment under Fannie Mae to better down payment terms, interest terms. She had to make that disclosure to the bank. It was not the mistake that she claims it was. It was premeditated fraud.
How much did she benefit from this? Give me a number.
All right. According to my calculations, now I don't have the exact terms of the mortgage. I had to use industry information. I estimate approximately $100,000, give or take.
Oh, so this is serious felony territory here now. $100,000 at the federal level. She defrauded the bank. Essentially, she defrauded the bank, right?
Right. But under U.S. law, and there's a Supreme Court case, I don't have it in front of me, but under U.S. law, they don't have to prove that she benefited financially. All the feds have to do is prove that she made a false statement to the bank, and that's what she did. Well, that's for the FBI to do in their investigation. In other words, what they're going to do is they're going to interview the mortgage broker, the bank loan officer. They'll interview Shanice Thompson, her co-buyer, co-borrower.
Right.
They'll interview everybody that was involved in that transaction. But in any case, irregardless of who they interview and what they say, the facts in black and white on pencil and paper from public documents say it's a fraud. And it is a fraud. Here's my guess, okay? Everything else I told you is fact, but when I say opinion. This is my opinion. I think that she was in a rush to respond to the DOJ inquiry, and she pushed them to write this hastily written response to it without actually researching the issues that are involved. In other words, by doing what he did, he actually buried his client instead of helping his client. He implicated her for mortgage fraud. Because if you read what she had written, her lawyer had written in response, that basically seals the deal. She committed fraud.
Why did she have to? Now, I understand that she was mortgaging this place at almost 92%. Why did she have to claim joint tenancy? Was that necessary to get the Fannie Mae?
If it was tenants in common, it would be an investment property also, which would trigger certain covenants under Fannie Mae. She had to buy this as tenancy, joint tenancy. Joint tenancy.
Joint tenants and right of survivorship, which is very common among close relatives, because what it essentially means is we're going to share the property equally, but if I die, it goes zoop right to the other owner.
Right, but it also creates an obligation that both joint tenants have to comply with the loan terms.
Right.
Not one or the other, both. And that's the way the mortgage was underwritten. Now, he did try to claim in his response to the DOJ that there was a subsequent document before the closing and after the power of attorney that contradicts the power of attorney. In other words, goes back to what she said on August 2nd and 3rd, that she didn't intend to occupy the property. The document that he pointed to, claiming that he had that document, was one of the earlier emails, not a subsequent email. But regardless, let's say that document exists, and they're now trying to sanitize it by producing that document. The fact of the matter is that the loan was still underwritten on the basis of her occupancy. She derived the benefits. She took no efforts to make any corrections whatsoever to the mortgage, and she's still deriving the benefits today because the mortgage hasn't been paid off.
When considering in the scheme of your life, your reputation, your pension, your status as the Attorney General, if it went the way it appears to have gone here, what a low rent fraud this is. Am I wrong? I mean, really?
That is correct, but you also have to look at the bigger scheme of things. She's been doing mortgage fraud repeatedly with a 296 Lafayette Avenue property in Brooklyn, saying it was 4 units with a governing structure. The certificate of occupancy says it's 5 units. She did at least 10 mortgages that way. Then there's another property in Queens that she bought with her father as father-daughter, but she signed the mortgage as husband and wife.
Now, that one I've never been clear on. We hear about that one. I know the statute of limitations ran on that one a long time ago, but what I don't understand is I've never heard that there's any advantage to buying it as husband and wife as opposed to your father being your co-signer. Do you have any clarity on that? Because I've never heard an explanation for that.
I don't, because Joe Gilbert uncovered that, and for me, it wasn't on my radar. It's
not one of the things, right? It's not one of
that wasn't worth my investigative effort, so to speak. The DOJ and the FBI are both vast bureaucracy. In any vast bureaucracy, you have competent people, you have competent but lazy people, and then you have incompetent people that are lazy too. I am not taking any chances, but here's one thing that has to stand out. She's been trying to say that the August 17th power of attorney was a mistake.
Right.
So implicitly, she's saying that she contradicted her previous intent.
It's an admission, which is a stupid thing. They shouldn't be talking. Lowell letting her talk is insanity, but go ahead.
Right. Now, the only reason why she got the mortgage, the way she got the mortgage, was because of her representation on the power of attorney.
Right.
It wasn't a mistake. It was an intentional lie to the bank in order to secure better loan terms than she would have gotten had she continued to tell the truth. The bank was not going to allow that mortgage to go through based upon her not being a non-resident borrower or with joint tenancy. Well, the lawyer shut up. She's still opening up her big mouth, making this like political retribution, which it's not. But even if it is political retribution, even if I burned down a firehouse yesterday, the facts on the ground shows that she's guilty. It doesn't matter. She committed a crime and there's no excuse. Let me give you an idea. She claims Donald Trump retribution. Well, you know something? She started committing mortgage fraud on a Brooklyn property in 2001 when Donald Trump was still a Democrat. I'm a Democrat too. The point being is I'm tired of this tribalism, okay? We're Americans first, party second or third, but we're Americans first. I started by looking at other New York City politicians. And then I said, let me look at our good friend, Letitia James. Looked at that, so extravagant campaign spending. Then I decided to look into a New York State financial disclosures, and then I got to the mortgages. So this was a process. I didn't target her. I didn't look for her. She fell into my pattern of looking at New York City officials, New York State officials. The Brooklyn one they seem to be ignoring. They're so concentrated on the Virginia one, which leads me to believe that they're really worried about Virginia. Whereas I think the strongest case is in the Brooklyn one, actually. Here she has a property that she purchased in 2001. The C of O, which was issued while she was probably still in contract, but before she closed, 2 weeks before she purchased the property, the certificate of occupancy says it's 5 units. Since 2001 to 2021, she's done 10 mortgages and refinances. And each and every one of those mortgages say 4 or less units, whether it's 4, sometimes she says it's a 1-family home, sometimes she says it's a 2-family home, but each and every one of those mortgages say it's 4 or less. The reason for that is under Fannie Mae guidelines, 5 or more units makes it a commercial property. Talking about political retribution, where the hell was Donald Trump in 2001 when she was committing mortgage fraud? Yeah, as I said, he was a Democrat, I think, at the time, if I'm not mistaken. And this gentleman, without identifying him, was in the mortgage industry. And he said that before the 2008 financial meltdown, there was a fraud known as the Big Fours, whereas properties with 5 or more units, they would classify it as 4 to obtain better mortgage terms. And the people that were in it were the appraiser that should have caught it, the loan officer that should have caught it, the title company that should have caught it, the mortgage broker. So there may be a wider conspiracy here. It may be a wider fraud than we know at this present time. But the documents itself, irrespective of what the FBI finds out from interviewing people, the documents themselves implicate her for fraud. Let me say this to you. When the FBI interviews, let's say in one transaction, you have an appraiser, a loan officer, you have a bank lawyer, whatever, and one of these guys lies to cover her. They're going to find 3 other people that won't cover her, and then they're going to go back to the person that lied to cover her, and they're going to say, you're going for perjury. She really has a lot to worry about, because she can't manage this situation. It's too wide and too broad with people that really don't have any skin in the game. Her state spending on private jets is...
They travel.
Yes. She spent about $40,000 on 6 private jet trips in around 2020, 2021, when she was Attorney General. No other New York State entity or governmental office used that carrier, which is called Venture Jets, Inc. When New York State stopped paying for it, her campaign did one more charter for about $14,000. So there's that connection there that she has with Venture Jets. Now, I foiled Freedom of Information law, both her office and the Controller's office. And you know what I get back from the New York State Controller's office? We have no documents. All we have is 6 entries on the ledger with various numbers. We have nothing to show you, period.
Yeah.
And I outlined in my book. Now, her office claims that they're going to have documents ready by July 17th. They were supposed to have them ready by around May 24th, but they didn't.
What is your response? Comment below. That's all for today. Thank you. If you want global news to keep you up to date on any new developments, please subscribe our channel and forward our content with your friends on social media and email. Thank you very much for keep supporting me. Stay safe. Be blessed. Namaste.
Thank you, God bless you, and God bless America.